Now, I did promise you at the beginning of this presentation that we would also be looking at key constitutional concepts that you need to grasp in order to really get on top of administrative law, either in theory or in practice. So let's embark on those, shall we? The first one we need to revise is separation of powers. And as you may have worked out from the first part of the quick tour, we need to have a reasonable understanding of that, because judicial review, administrative law judicial review, involves the court in only considering the legality of the decision, whereas in merits review, the tribunal considers the merits. It stands in the shoes of the original executive decision maker and is expected to make the correct and preferable decision. So judicial review is an exercise of judicial power, and merits review is an exercise of executive or administrative power. Now, in the US version of separation of powers, it was first authoritatively enunciated in Marbury and Madison, there was and is a fairly strict and complete separation of powers between the legislature, or parliament we call it, the executive, which is the Governor-General or the Governor or Administrator in a territory, and of course the ministers and public servants. All of them together are the executive. That sort of complete, and of course the courts. That sort of complete separation, though, between the legislature and the executive isn't possible under the Westminster system of responsible government that we have in Australia. And that's because in Australia, ministers who are in political charge of the executive arm of government must be members of Parliament, so that a strict and complete separation between legislative and executive power doesn't exist. Now, you can contrast that with the US situation, where ministers or secretaries of state or whatever are appointed by the elected president and are not permitted to be members of Congress. However, it is also important to note that in all other respects, there is a separation of powers between the Parliament and the executive, as numerous federal MPs and senators have discovered to their cost over the last couple of years. All of the cases about Section 44, where ministers or MPs have found out that they may be citizens of a foreign power, for instance, and therefore disqualified from sitting in Parliament. That's included all sorts of quite prominent people, including Barnaby Joyce and others, of course. You'll all, no doubt, even if you don't follow politics very closely, remember that whole saga, and it's probably not over yet. As I go on to say, moreover, separation of judicial power, though, from the other two arms of government, the legislature and the executive, is very much complete and jealously protected by the High Court of Australia. I'm not going to go into that in detail. I've mentioned a couple of the cases there, but it's mentioned in a bit more detail on the written version of the Public Law Quick Tour, which I'm hoping you'll read as well as listening to this. So at federal level, only courts can exercise judicial power, and they're not permitted to exercise non-judicial power. And conversely, persons or bodies who are not courts of law are not permitted to exercise judicial power. They can only exercise executive or administrative power. Now let's reprise exactly what is judicial power. I'm not going to go over this in detail, but I would ask that you read the written version of the Public Law Quick Tour on this, and perhaps revise your constitutional law study guides as well. There are 4 key points to remember on judicial power. Firstly, an exercise of judicial power will involve a dispute between citizens or between citizens and government about questions of life, liberty or property, and where legal rights are to be determined in a final, binding and conclusive manner. Courts of law exercising judicial power do not give advisory opinions, the High Court has said. They determine legal rights, duties and liabilities in a final, binding and conclusive manner. Secondly, a court exercising judicial power, generally speaking, determines existing legal rights and existing legal rights, duties and liabilities, given that the duties and liabilities go with the rights. In some respects, they define legal rights. So the court is there to determine existing legal rights, duties and liabilities and make orders about, in effect, to enforce them. It is not there to determine future entitlements. So if you've got a body that decides whether someone should get a license or a permit or a social security benefit or a visa to enter Australia or a planning or building permit, anything like that, and there's lots of other examples, is not something that is typically decided by a court exercising judicial power, because determining whether you should be granted an entitlement that you don't presently have is an exercise in executive power, not an exercise of judicial power. Exercise of judicial power would be to determine whether somebody who already does have a legal right that's been conferred by the grant of a right or a permit or a license or whatever has breached the terms of that right, or whether somebody has breached their rights in a way that entitles them to damages or some other remedy. That would be an exercise in judicial power. So you see the distinction between judicial power and executive power? Thirdly, generally speaking, a court exercising judicial power has to be in a position to decide the dispute in accordance with reasonably objective, determinate criteria, rather than by vague, subjective or policy-oriented criteria. And if the decision is one that involves policy-oriented, subjective, vague criteria rather than reasonably determinate ones, there's a pretty high probability that it would be determined not to be an exercise in judicial power, but rather an exercise in executive power. Because governments are elected, of course, to make policies for the people and to make decisions to implement those policies. So that's executive power. So if you've got a type of decision that's characterized by needing to make policy type subjective decisions, allocating resources, for instance, between competing applicants, that's likely to be an exercise in executive power, not judicial power. Fourthly, and this is important because it delimits the differences, if you will. Executive or non-judicial bodies like the AAT, VCAT, NTCAT and so on can determine facts conclusively, and they can even decide on legal rights and duties, just like a court, provided that there is a right of appeal or judicial review on all questions of law. That is, it would be unconstitutional for Parliament to enact a law that conferred a power to make final, binding and conclusive decisions on a body that isn't a court of law. At least that's at federal level. At state level, it's a bit different, as we'll look at when we look at the Administrative Appeals Tribunal and contrast it with VCAT and NTCAT and all of those state bodies next week. So Statement 4 here is especially applicable to federal courts versus federal tribunals. It's less applicable at state level. Now that will probably be confusing to you at the moment, but hopefully it will all become clear as we carry on. Now, reprising representative and responsible government. It's important that we understand this, because at the end of the day, what we're dealing with is what, to what extent and in what way should the judicial review administrative prerogative writ power of a superior court be exercised, given that our Constitution vests executive power in ministers and the departments that they're in political charge of. That's why we need to understand the constitutional doctrine of representative and responsible government, because our Constitution, being based with some modifications on the Westminster system, is one that embodies the principles of both representative and responsible government. Control of executive departments and agencies rests with ministers. First, ministers are responsible for ensuring that the executive branch carries out the policies of the government. So the departments and agencies, the minister can make sure they carry out the government's policies as long as the policies are consistent with the Act. Each minister is answerable to the Parliament and is accountable ultimately to the electorate, individually and collectively, for actions taken within the executive branch. And that, of course, is because all ministers are constitutionally required to be members of Parliament. Now, you might want to click on section 64 of the Australian Constitution and have a look at that. You'll see that ministers must be members of Parliament. They're not allowed to be not members of Parliament for any longer than 3 months. So, therefore, they're accountable to Parliament and ultimately to the people, because they're members of Parliament and therefore they stand for re-election at federal level every 3 years or so. And sometimes they pay the ultimate price for not doing what the people wanted. So, for example, John Howard was Prime Minister, but was not only lost the election in 2007, but also lost his own seat in Parliament. And there have been other examples of that in the not so distant past. And as I've said before, that's in contrast to the US situation, where neither the President nor his or her ministers, called secretaries, for example, the Secretary of State, must, I've made a grammatical error there, neither of them must be members of Congress or senators. They're not allowed to be. Lastly, government accountability in general terms through Parliament is about lines of authority and answerability, or the transmission belt process of accountability, if you will. So accountability is enforced by that multi-part process. Next, have I got a deal for you? I've found some very useful quizzes, true and false, and multi-part quizzes, A, B, C or D type quizzes at the Australian Parliamentary Education Office. They're fairly simple and basic ones, but they're useful. I do strongly suggest you do them. There's feedback after each one to tell you what the right answer was, so it won't bust your brain or anything like that. It's not accessible or anything like that either, and nobody will know other than you how many you got right and how many you got wrong, so you might as well have a go. I think all of them, all of the quizzes, there are several quizzes there at that page if you click on it and have a look. I would suggest that you do all of them down to the quiz titled Types of Law, bracket statute, common and delegated. It won't take you very long, and I think it's useful revision, and you may even learn something you didn't actually know up until now. So that's good. It's up to you. You don't have to do it, but I strongly suggest you should. Good way to learn. Now you'll remember I've already talked about what public law is in this presentation, but that also requires us to think about, well, what is the distinction between public law and private law, or at least between what is public and what is private in terms of subject matter. We will come back to this topic in the other multimedia presentation that I'll be asking you to listen to this week for week 1. The public-private distinction is increasingly problematic in this era of privatisation and corporatisation of functions that have traditionally been regarded as public. To what extent, if at all, can or should public law accountability mechanisms like merits review, judicial review, freedom of information and so on be imposed on government business enterprises as opposed to the public service properly so called? Australia Post, for instance, and other wholly or partly government-owned businesses, if you will. That dilemma is especially acute where the government business enterprise is competing with a private sector provider of similar services. Now, most of those sorts of bodies have been flogged off years ago. I mean, Telstra used to be publicly owned, but now it isn't. Qantas used to be publicly owned, but now it isn't. But Australia Post is still publicly owned. So, and Australia Post, of course, does compete with private providers of postal services, especially parcel delivery services and so on. FedEx and Toll and bodies like that compete head-to-head with Australia Post. But the private competitor in that sort of situation generally is not subject to public law accountability mechanisms and therefore has a lower cost structure than a government business enterprise, which is constrained by those requirements. Now, one answer would be to impose similar accountability requirements on private sector providers of services that have traditionally been regarded as public. Now, that has tended not to be done in Australia, although that's perhaps starting to change. The views tended to be taken in Australia that it's better to outsource everything and privatise everything, and that somehow competition between competing private providers will provide the fairest and most efficient service for taxpayers. Whether that's actually true, I'm not at all sure. If any of you have ever had experience in dealing with the jobs network that took the place of what used to be a government department that helped unemployed people find jobs, I'm not sure that it's either more efficient or fairer than the old system. In fact, most people who've dealt with it tell me the opposite is the case. In any event, there's a lot more on this topic in the written version of the Public Law Quick Tour in the document titled What is Public Law, and I do strongly encourage you to read that. And as I say, we'll be coming back to issues surrounding the public-private distinction and privatisation and related issues in the second multimedia lecture presentation for week 1 that you'll be listening to hopefully very soon. Now, here's another seminar question that we will be discussing in the Week 1 live seminar, and it's about precisely the issue I've just been talking about. Should private companies be subject to the same accountability mechanisms as government departments? What are the pros and cons? Does the position change for private companies delivering, quotes, government services, or for other bodies such as universities or sporting authorities that wield quasi-governmental powers? So if they've got powers and authorities that are underpinned by statute, then even though they're nominally private bodies, should they be subject to public law remedies? That's something we will discuss in the Week 1 live seminar. Okay, we are reprising rule of law here, because the concept of rule of law is also one of those underpinning constitutional concepts that we need to understand to have a full understanding of administrative law. And that's because when a court is undertaking judicial review of administrative decisions, or an independent tribunal is undertaking independent merits review of executive or administrative decisions, it will have questions of rule of law in mind. It will be looking at and will be amenable to arguments from you as a lawyer for an aggrieved litigant that the decision maker has failed to act in accordance with basic principles of rule of law. There are, sadly, at least in, this is very much my personal opinion, but it's one that's held by lots of people, there are some departments and agencies at federal level especially that do have a reputation for sometimes not taking rule of law questions very seriously. For instance, Centrelink's administration of the so-called robo-debt system that they implemented a couple of years ago has been very controversial and arguably does not comply with the rule of law. Similarly, some of the ways in which the body called the Australian Border Force, once the Department of Immigration, exercises its powers in relation to refugees and asylum seekers might well not be in accordance with rule of law principles, and certainly courts frequently find against these bodies, not necessarily expressly on rule of law grounds, but as a lawyer acting for somebody in such a situation, you would be wise to run a rule of law argument, because even if the court or tribunal doesn't expressly ground its decision in rule of law, it will be influenced by it in finding that there was a breach of the department or agency's statutory obligations properly interpreted, and properly interpreting those statutory obligations will involve deploying rule of law principles. Now, there are some more modern concepts of rule of law. Of course, A.V. Dicey was writing back in the late 19th century. The scope and reach and complexity of government is much, much, much larger today than it was in the 19th century. So questions of rule of law and the complexity and nature of what should be regarded as rule of law have changed over time. So Joseph Raz, that's him down there, he's got a beard a lot like mine, really, actually, when it gets right down to it, and possibly even less well-tended than mine. Some of Raz's rule of law principles are: laws should be prospective rather than retroactive. People cannot be guided by or expected to obey laws that have not as yet been introduced when they broke them. Now, that having been said, the High Court has repeatedly found, most notably in a case called Poljakovic, that the principle of retrospectivity or non-retrospectivity of laws is not constitutionally guaranteed in Australia. So if an Australian piece of legislation sufficiently clearly and unequivocally demonstrates an intention to operate retrospectively, then the court must enforce it. But it won't do so if there's any room for it to find that it wasn't, if properly so interpreted, intended to operate retrospectively. Secondly, Raz says laws should also be open and clear to enable people to understand them and guide their actions in line with them. So the principle is that desirably legal drafting, parliamentary drafting, should be open and clear in plain language, plain English drafting, not lots of whereases and wherefores and heretofores and, archaic language like that, that makes or may make the legislation completely incomprehensible. Now, the trouble with that is that especially at federal level, even though they've removed all the wheretofores and herefores and whereases and so on, Commonwealth parliamentary drafting is almost mind-blowingly complicated and convoluted. There are numerous acts of Parliament that are so complicated that even a very experienced lawyer and sometimes very experienced judges struggle to work out exactly what they mean, because they are so convoluted and complex, and they refer back to other sections and forward to other sections and back to definitions and sub-definitions and so on, and they're almost impossible to understand. Now, one might argue that that does breach rule of law, but you probably wouldn't succeed on that, except to the extent that if the law properly interpreted requires intent, mens rea, to be breached, even if it's not a criminal law, then you might well have a very powerful argument that it was almost impossible to understand it, and therefore your client didn't knowingly breach it because they didn't understand what the hell the parliamentary draftsman was talking about. Next, laws should be stable and should not be changed too frequently, as this might lead to confusion as to what was actually covered by the law. And there should be clear rules and procedures for making laws. So all of those things, according to Raz, are part of the concept of rule of law, which if breached might ground an argument that not so much the law, but the administrative decision made under the law may be held to be invalid. Now we're nearly finished. Just a little bit more on Joseph Raz's rule of law concept. Independence of the judiciary has to be guaranteed to ensure that they're free to decide cases in line with the law and not in response to any external pressure, especially by politicians. Principles of natural justice should be observed, requiring an open and fair hearing to be given to all parties to proceedings, and that, generally speaking, applies in both courts and independent merits review tribunals. Principles of natural justice do generally apply. Now, that correlates to, although in a non-constitutionally entrenched way, to the principles of due process that are entrenched in the US Constitution in their Bill of Rights. We don't have a guarantee of due process in our Constitution, although one of the key founding fathers in Andrew Inglis Clark tried to get a guarantee of due process in the Constitution and only narrowly failed. But even though it's not entrenched in the Constitution, Raz argues, and indeed the High Court so interprets things, the principles of natural justice, generally speaking, will always apply to the proceedings of both courts and tribunals, unless and to the extent that they are expressly and unequivocally removed by the clear words of an act. Now, sometimes that will happen, and we'll look at that later in the semester. But usually it won't. If a court or tribunal can find a way to rule that natural justice should have been given but was not by the statutory decision maker, then it will so find. Next, the court should have the power to review the way in which the other principles are implemented to ensure that they're being operated as demanded by the rule of law. I won't go into that. Courts should be easily accessible as they remain at the heart of the idea of making discretions subject to legal control. Well, by and large, the courts are easily accessible, although sometimes filing fees are extraordinarily high, and often the area being litigated will be so complicated that really you can't effectively represent yourself without a lawyer, and lawyers are very expensive. So the extent to which courts are easily accessible in Australia is questionable, and that's one reason why we have independent merits review tribunals, because generally speaking they're fashioned in such a way that you probably can represent yourself without a lawyer, and lots of people do. You're still to some extent disadvantaged, but you can do it, and lots of people do. Lastly, the discretion of the crime preventing agencies should not be allowed to pervert the law. Very important, given that every state and territory now has both an anti-corruption commission and to some extent an independent crime preventing agency. So at federal level, there's the Australian Crime Commission, for instance. Very wide powers, including powers to force people to answer questions even if they might incriminate themselves. And so because they have such vast powers, RAS's rule of law principle is very important in that respect. It's largely honoured in Australia, I might say, so that's good. Now, you'll be pleased to know that we're just about finished this first recording anyway. The last seminar question that we'll be looking at in the week 1 seminar, and I might say we'll be looking at this question, or a variation on it, every week. What would you rate as the 3 most important basic concepts discussed in this quick tour and the introductory lecture video that you're also about to look at, from the perspective of underpinning government accountability and integrity? So we've talked about lots of things. What are the 3 most important basic concepts, do you think? We'll probably adjourn into the breakout rooms in Collaborate and discuss these in groups, and then come back into the main room to discuss them between all of us. And lastly, list 3 concepts that you don't fully understand and or would like discussed and explained more fully in the weekly seminar. So on both of those questions, I'd like you to have a think about them between now and the week 1 seminar. Perhaps come along with a few notes about things that you don't fully understand, and we'll try and deal with them, because that's what the class is all about. So that's the end, except I'll foreshadow what we've got coming up. But wait, there's more, the slide says. It draws on a series of TV ads that some of you might not remember, but they used to be so frequent that they'd drive you completely mad. They were usually ads by a company called Demtel, and they always started out with the words, "But wait, there's more! Not only do you get the steak knives, but if you ring now, within 5 minutes, you will also get a set of free carving knives and a chopping board and various other things as well. Have we got a deal for you?" Well, that's the case here as well. But wait, there's more. This is the first of 2 multimedia presentations that we want you to view and listen to in semester week 1, preferably before you attend the initial live seminar. The second presentation is titled Introduction to Administrative Law, and it's again a fairly substantial piece of work, and it's found under the link to this recording in the topic/week 1 learning materials folder. But you'll be relieved to know that after this week there will usually only be 1 multimedia lecture presentation each week, and it will generally be of around 1 hour in length only. And however, it is hoped or expected that you will listen to it each week before attending the live seminar for that week, so that you can usefully participate in class discussion on the topic. So for instance, we would be hoping that you'd listen to the recording on week or topic 2, which is about merits review tribunals, the AAT and VCAT and NTCAT and so on. We would be hoping you would listen to that on the weekend at the end of week 1 prior to attending the week 2 live lecture or seminar. Okay, I'm hoping that I've explained that clearly enough, but you'll get used to the sequence of it all and the organisational structure soon enough. So that's all for the public law quick tour, but please go on as soon as you can muster the time and intestinal fortitude for it to the second presentation titled Introduction to Administrative Law.